Hi, everyone. Carl Steinbeck here. This Saturday night, I want to talk to you about how to improve the closing argument for the Karen Reed 2.0 trial. I've looked at the Karen Reed 1.0 trial closing argument by Alan Jackson, and there's some pointers I think that would be helpful for the defense. Me as a trial attorney, I don't like anybody else critiquing my work. I've never seen somebody critiquing mine because there hasn't been anything where I've had a case on live stream or YouTube or anything like that for people to critique. But just from the many trials I had, the successful outcomes I've had in my cases, I believe there's certain core principles and tactics and strategies that I use to make sure I connect with the jury and the jury understands the seriousness of what they're called to do and how the evidence that's been laid forth before them does not meet the burden of proof that the government has on their side of the house. So what I do is on this case, I've looked through it all and just had different things pop into mind. I'm not going to do my own closing for this case because I'm not good at acting, and so basically, there's so many different things that that are little nuanced details and whatnot that come alive at a trial. So what I do is when I'm going through an actual trial, I'm taking a few notes after a witness, maybe some important things to keep fresh in my mind for my closing. And then when I do a closing, I actually don't have any notes. I don't stand behind a podium, and I just stand about 10, 12 feet in front of the front center juror and then make that direct pitch to the jurors. And I try to connect with them with eye contact and change my cadence and tone depending on what I'm saying. So I don't want to come across like I'm a robot or anything. And so it's very important also to tell a story. And through that story, then you can also, after the story is told in more of a minor fashion, then you can go into the more extreme details of each particular character. So that's sort of the general approach I use for closing. And I also tie it in with my opening and maybe some things on voir dire, because a lot of the themes I use on the case are consistent from voir dire to opening to closing. And so I can remind the jury, you remember in voir dire, and I may even cite, I find it useful to even cite something that one of the jurors said as a response to one of my questions. So I like to have that kind of dialogue with them, and then use that kind of thing to continue that dialogue and say the things that are consistent across the board, like I say, from voir dire to opening, and then drive it home on the closing. And then I also talk about how I promised you in my opening that the government would not be able to prove their case beyond reasonable doubt. And in fact, I would prove to you beyond reasonable doubt that Karen Reed is not guilty. So I've delivered on that promise and commitment to you, and this is why, and then go into it that way. So the with that, now I'm going to go ahead. That's sort of a general overview. With that, now I'm going to go ahead and let's jump right in here to Alan Jackson's closing. And like I say, you got to have, as a trial attorney, you got to have a lot of continuity between your opening and your voir dire before that, and then your closing. So they sort of all come through together, and also with your witnesses. So I look at a trial attorney as basically like a movie director. So what I want to do is, like, I'm the director, all the other characters and actors and evidence are the thing that is the movie. I'm not the movie, even though I'm sort of the face of the one arguing. It's my voice doing the questioning, and I'm standing before the jury all the time. They can see me when they're not looking at the prosecutor. But what I want to do is have it come out like a movie where it's very engaging for them. I'm not dragging out questions. I'm not doing a lot of objections, trying to basically make it a boring movie. I'm trying to make sure that it captures their attention, and then they understand the seriousness of it, and I'm not bogging them down in needless minutia. So there are finer details, obviously, of cases that are absolutely critical, like we have in this case here, and how they all link together. You got to bring that all home for the jury. But in any event, with that, let's go ahead and get started here.
In Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
Okay, this is something I've never seen before, where the state goes after the defense in the closing arguments. It's really odd because normally whoever has the burden of proof, they go first, and then the defendant goes after the prosecution, and then the prosecution gets a rebuttal to rebut anything the defense said, because the prosecution doesn't have the burden of proof. So here, for the defense to go first, I think it's a disadvantage to the defense, because the prosecutor could come up with some new angles of attack in the argument, and it's too late for you, the defense, to say anything. You have to anticipate what the prosecution is going to say, poke holes at it, and you cannot rebut anything they say. And what I always do is dare the prosecutor to talk about at least 3 or 4 things that came out at trial, and I'll dare them to talk about it and address it. And every single time I've had a trial, they never do it, because they can't, because it shows the fallacies and flaws and how defeated they are in their case. And what happens is, I explain that if they don't address each and every one of these, the prosecutor realizes that they have not proven their case, that indeed what I've promised you is that, and I never say my client, I always humanize my client. So in this case, if I was representing Karen, I say, Karen Reed, I told you in the beginning, and I've proven that to you, that indeed the evidence is borne out, the fact that she is not guilty. And so that's one way I do it. So let's go ahead and go on here. It's just very disjointed to have the defense go first. I think it gives an advantage to the prosecution. Like so many things that are in Massachusetts criminal law setting, it works an advantage to the prosecution and not the defense. And it's very much, it's another way to tilt the scales. And, she says in Massachusetts. Why is she saying in Massachusetts? Is that she's playing for the audience here, the world audience? Hey, this is the way we do it here, to not make it look like she's the one directing this odd sequence of arguments. So anyway, I just note that it's just an unfair advantage to have the defense go first, and then the prosecution gets to try to mop up.
Thank you, Your Honor. Look the other way.
I would just say one thing about the dress of how I come across, and also my clients. I want my clients to dress semi casual to semi dressy, and Karen's obviously a highly successful businesswoman, and that's what she feels comfortable with. I would not have her change up her attire at all for this. She actually looks like a lawyer in the courtroom. I don't really like the idea of my client looking like a lawyer, but that's the way she dressed in the first trial. And so I would not recommend any change for that. But if this was like the first trial and she was my client, I'd probably say we don't want to go so much the power suits, because you're less sympathetic to the jury. And so maybe more like more of a casual business type attire. As an attorney, I do not like the idea of having a white handkerchief in your pocket there. I've never worn that. I think it looks very, very slick and professional, but I think it looks a little bit too sophisticated, too much of a, like you're a powerful lawyer for the rich. And so I would try to do something to downplay this kind of, I have a rich client. I'm a super high priced lawyer. And so I just saw like sort of more of a less, I guess, formal type of look by having a white handkerchief there in your pocket. So, I mean, it looks very classy. I'm just more of my approach is more like downplay the classiness a little bit to try to connect with the jury. Because the more you try to make yourself more of a sophisticated type lawyer, the more you use sophisticated words and language, the less you can connect with the average juror. So let's go ahead and see what he then says here. He starts out by saying,
Thank you, Your Honor.
This phrase here.
Look the other way.
So right there, he's making direct eye contact with the jury. That is good. He's bringing a notebook up there. As soon as somebody's bringing a 3-ring binder notebook, I like sort of cringe, because I'm like, this is not hopefully going to be something that's read a lot off of a script. But he then jumps into look the other way, and let's see what else he says after
Look
that.
the other way. 4 words that sum up the Commonwealth's entire case.
So right there, when he's looking down, you're losing connection with the jury. I do not like that. If I was his mentor, I'd be saying, Alan, you got a great voice, you got a great delivery. But looking down at your notes right after you make forward statements, I just don't like that approach. And so that's what my my advice would be for him on that.
4 words that sum up the hopes of those
Looking down
who
again.
have tried to deceive you. Conflicts of interest.
Okay, right away he's getting into conflicts of interest. How's that significant about this case? I do not. Granted, it's conflicts with the cops and the loyalties to Canton and all this kind of stuff, and but he's not telling a story. My whole thing is you got to start out maybe humanizing John O'Keefe and make some point about him being, somebody that was brutally beaten to a pulp and attacked by a dog. If that's what your theory is, start out by saying that. And as I told you in the opening, I proved to you that he was not hit by a car, and the evidence has shown that to be indeed the case. And
Matter. Just look the other way.
so he said multiple times now, just look the other way. And so I'm not, I guess, a big fan of saying look the other way. I'd rather just start getting this storytelling of what happened that day, or how they, just real in 10, 15 seconds saying, look, Karen loved John. They had a long-standing relationship. She helped raise 2 of his kids that he's raising for his deceased daughter. She loved the kids. She loved John. And they had a good night that night when they went out. And then sort of have that flow into it that way.
Magic hairs. Magic glass. Look the other way. Late night calls and Google.
So again, he's doing different points that came out during the trial, and then he's saying, look the other way. So look the other way. I get what he's talking about here. He's saying, look the other way. Don't look at all the evidence that points to something other than Karen.
Searches, falsified affidavits, inverted videos. But
look how much he's using that 3-ring binder. I just do not like that. Like I said, he should be front and center of the jury. No lectern to be used at all. You just have that direct eye-to-eye connection. You speak from the heart. And so, yeah, Maya Rodriguez, who's also attorney, Sorensen, is saying you can tell Jackson's suit costs around $6,500. You might want to downgrade that to a $1,000 suit. Yeah, I mean, you could have a nice Hugo Boss, Armani, or something like that, $1,500 or less. I don't know what kind of suit this is. I don't own one because it doesn't do you any good as a trial attorney.
Dials galore. Just look the other way. That's what they want. That's what they're counting on. But the uncontrovertible fact is you have been lied to in this courtroom.
Again, looking down. Okay, yeah, they've been lied to. Again, I just rather he's not telling the story yet.
And your job is to make sure you don't ever, ever look the other way. Your singular duty is
now he's talking about their duty as jurors or juries not to look the other way, which is what he's saying the Commonwealth wants them to do. I don't see that really compelling as of yet.
to stare down the evidence and do it unflinchingly and do it unwaveringly. You see,
Words like unflinchingly, unwaveringly, those are sort of bigger words. I try to break it down more to lay terms that sort of like how you would talk to somebody if you're just at a coffee shop with them, you're sitting across the table from them, just talking, hey, tell me about this case. Well, and then you go into it. And so more of a folksy, down to earth type of approach at times, but also you need to be very strong and forceful and powerful in your voice when the time comes right.
you're the only thing standing between Karen Reed and the tyranny of injustice.
So he's saying they're the only thing that's come between the Karen Reed and the tyranny of injustice. Again, he's not telling the story. Tyranny of injustice. You're standing there in the gap. I would rephrase that differently and say it more towards the end of the case, not at the beginning.
It's a job you didn't ask for, probably a job you didn't want.
Okay, a job you didn't ask for, a job you probably didn't want. So he's right here saying that the jurors probably don't want to be sitting here listening to him and just listening to all the case. I just don't think that's good at all. Um, if anything, I'd be like saying you got the opportunity, make it sound, put a positive message behind it. So you have the opportunity to do justice here that's been denied for John O'Keefe and Karen Reed for multiple years now, and it will continue unless you do the right thing. And so that's I think more of a way, a positive way to say they have the power now. The power has been uh, in the hands of Hank Brennan, but you now have the opportunity to rip that out of his hands and do the right thing and finally do justice that's been just run roughshod over for the last 3 years.
But it's the greatest responsibility we have as citizens here in America, lest the government stop answering to us and we start answering to the government.
Okay, that's sort of like a generalized, hey, we got to have, mutiny. We got to have sort of a little revolution here of the justice system in this town here. So I'm just not a big fan of this approach here. Again, please get to the story. What happened, AJ?
And low betide any one of us,
Look,
who
he's
might
got his
find
hand on there,
ourselves in
following
the
the script.
crosshairs.
Could be any one of us if it gets in the crosshairs. I mean, this sounds like, yeah, it just sounds like way too much pointing the finger at the Commonwealth. It's us against them kind of stuff. And I don't know. It's just you haven't told the story yet. So you got to tell the story before you say why you need to take some kind of action, how important it is to take action.
Of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth.
Okay, so now he's talking about preparing for today. He's reminded of a quote. So he really inserted this into his script just this morning, right before this this argument started. So I automatically would think, okay, this is written in the script, and it's not. He's not credible. So you're thinking he's just reading a script. He's not talking from the heart. Do you really think that he just inserted this into his written out argument that morning? It just maybe he did, maybe he didn't, but I just think it looks contrived and it's not speaking from the heart. So that's just me.
And I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible.
Look how much he's reading. Alan, get off your notes. You can do it. You are a smart attorney. You've been sitting through this thing for a long time. You've got many years experience and you can do it. Just get that podium away from you and just connect with the jury. Because right now you're not doing enough job to connect with the jury, and you could be losing them by now. You need to really come on strong and get to the heart of the case.
And those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time it depraves all its good dispositions.
Telling some lofty quote when you just got an hour and you got all this truckload of evidence to have to go through, and I just think it's not productive use of time.
What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks,
he's arguing like philosophical type stuff here. He needs to get right to the storytelling.
Is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or
look how much he's reading. He knows his case inside and out.
Listening, how he would make a case, how he would make it cut and dry, no matter the truth. How he would make sure to put,
like
quote,
it's like he's reading out of a book. Some of you saying, can't stress enough reasonable doubt. He's not branching that yet. We're almost 3 minutes into it.
serious charges on the girl. In other words, pin it on the girl.
Almost reading a book here. This is not going to connect with the jury.
You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth.
Okay, why are you saying that people wouldn't believe that this is possible, that there would be a cover up? I just don't like that. I know what he's trying to do. He's trying to say, yeah, people just generally think, hey, people aren't going to come to court and lie, and so many cops are going to lie and circle the wagons. But anyway, I don't. I would never concede a point like that.
Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie.
He turned the page here.
Over and over and over. They and others were caught deceiving you. Big things, small things. It didn't really matter.
Well, those are the kind of things you need to iron out in details, both in your storytelling and then go even further when you're talking about individual witnesses as a summation of each of the government witnesses.
They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered.
Okay, so how's butt dial significant? He's not driving that point home here.
They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way.
I would never point it at anybody on the jury. I don't think that's a good approach. I think right now he's getting a little bit more, showing that he's a little bit more incensed that this is wrong, the way this has been approached. And so I get the point he's trying to make. I just would never point at the jury like that. All right, I just want to see if there's any questions here to bring up. I guess you guys have mostly comments on going through this. Estrella, you're saying explaining reasonable doubts to the jury is very important. Yes, absolutely true. GB, you're saying it was so obvious not guilty, they got too confident. I don't know if that's the case. It could be. Selmy B saying his closing was terrible. Should have gone through the jury forum. Yeah, definitely should have gone through the jury forum. Like we all saw, it was really sort of a messed up deal. And Rainy Day Girl, you're saying you thought he had a short notice to cut it maybe an hour and a half, hours out, if you recall, off his game a little bit, choppy thought process may have result. Yeah, that could be the case. It's it's one of these deals where I think if you had a script and trying to shorten the script down, it's going to be a lot more of a challenge. So if you speak from the heart, no script, you're going to be able to adapt for whatever time frame you're allowed to have, even if it gets shortened on and with this an hour and a half notice. Glenda Carringer saying you agree that keeping eye contact with the jury is much more effective. It also shows the most important thing is not just connecting with the jury from the standpoint of eye contact and making sure that that you can read what they're thinking about what you're saying to some extent, but I think that they know you're speaking from the heart. If you're looking at the script here, you could have anybody that doesn't know anything about the case is go in there and say, hey, read this script. You could even pull an actor out there. They could really do it good. But you pull any trial attorney and say, hey, can you read the script in a closing? You know, how do we really know he knows the case and speak from the heart versus somebody that just is handed a script and say, hey, go argue this in front of this jury? So that's, I think, is a good way to note the difference between the two. Tall Glass, you're saying you're drawn to attorneys that don't have notes and approach with speaking only. That's because they're speaking from the heart. That's what I'm saying is that if you speak from the heart, you're automatically going to have some buy-in credibility with the jury. Stevie Howell saying he needs to focus on the human element. He lost his life that night. Karen lost her freedom and career, and no one has been held to account because of the botched investigation for us to justice. That sums it up. Very nice. Yeah, he should have gone through the jury form. He's talking too much in riddles. Rainy Day Girl. Yeah, that's one way to say it. You need to come on strong and just blast these clowns out of the courtroom. So, all right, let's go see what else he does here.
Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog.
He hasn't told the story yet, so going through these so quickly like this, how cover-up is, it's just sort of not connecting because he's reading it also. These are some good points he's raising. All this is accurate, but if you're not connecting with the jury and you got to read through it, it's just you're losing a lot.
Destroy your phones. Destroy your SIM card.
Those are huge points. Destroying phones and SIM cards right before a protective order is coming out. Obviously, you got some inside intel, some inside intelligence from the law enforcement types, or from a judge, let's say. So it obviously is a shady justice system there.
The investigator decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit.
Okay, every one of these is a reasonable doubt. So he's not spelling out as a reasonable doubt. So these kind of things he could point out through the different witnesses or collectively bring it up in his argument. But I think you need to do a storytelling in the beginning first. Again, too much reading.
Witnesses' names, omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos.
You know, all this kind of stuff he's arguing about how they botched the processing of this investigation. You know, they're not going to have the FBI agent Easter talking about that. So this is all going to have to come from his cross-examination, or whoever the defense attorney that's going to cross-examine these government investigators to then try to poke holes at it. So they automatically have a big disadvantage. But you would think jurors understand that this is really not the way police should be processing a so-called crime scene and determining all the different minute details that are very critical. And so anyway, he's raising great points. I think it's just a little bit premature here from the storyline.
Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative.
Yeah, this is all like weaving in a little nuggets, really super nuggets of information. But then he's talking about in theory and then talking about the government's theory and how this whole thing developed. I mean, a conspiracy, it's sort of like he's not really like breaking it down. We're like, this is what just happens. That something happened quick in the house. They had to cover it up, and they're all cops and tied to cops. So they're not gonna say anything happened. And just like we got the text message blast from Brian Albert, the detective of 30 years from the Boston Police Department, he said he never came to the house, right? All right, that's it. He never came to the house. And if we all say he never came to the house, guess what? They're going to leave us alone because I'm a cop and it's happening in my front yard. I mean, that's all that happens. And then everybody shows up and they're told what happened. And this is Karen Reed dropping off. She's the last one to see him. So obviously she knows what happened to him. So that's how easy it happens. There's no big elaborate scheme. And you're not going to have text messages saying like, hey, how can we all get together? No, all these little data points of how they all got together, text messages like the one from Brian, and how Jen McCabe was doing so much from the 911 call and everything thereafter that she's involved in. It just shows how much that these points he's making are absolutely spot on. But like I say, it's just a little bit disjointed and not flowing properly.
Instead of the other way around. Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Reed. They desperately resorted to calling witnesses to talk about Karen Reed and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what...
He's jumping around a lot. It can be hard for a jury to follow this. So, like I say, he's moving a lot through quick, a lot of different points. He's pulling out from a lot of different areas. So it's a little bit harder for a jury to follow this kind of timeline. So, GV, you're saying that Unetti also had a great storytelling and we could follow, and we didn't know any witnesses' names yet. So, yeah, it's a lot easier to tell the final closing statement, driving home all these, your main storyline, and then doing dovetail into each particular witness, how they support that after you've done your overall story.
Anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey.
Yeah, see, I just brought that out in the opening. Hey, they're a good couple. They're steady. They're having a wonderful night, and just jumping in it here 8 minutes in, you're sort of like constantly moving around, and so I just like more of a sequential timeline of things. My mind moves around so much. My mouth has a hard time keeping up with my mind, and so that's to me why it's very important to do sequential order of events. And plus, the jury can relate to it too, easier that way. Natalie, Jeannie, you're saying how important is closing arguments? Do jurors put a lot of weight on them? I think they do put a lot of weight on them. Obviously, you got to have credibility. You got to drive home the points, and you can win a case based on your closing. But obviously, if you have great witnesses, but you don't really pull it together, you could lose momentum of the case. So yeah, you could lose your momentum you had going in there. And if you don't drive the points home and talk about how the other side has failed miserably, then yeah, you may wind up with a loss that you otherwise could win.
No issues, no toxicity. They were a loving couple right up into the time Karen Reed dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all power.
I don't like the more aggressive approach saying the point you have to ask yourself, you must ask yourself, that kind of stuff is like the jury doesn't really have to do that. I would urge them to consider, maybe it's a softer approach to do that. I don't like sort of saying you must consider the fact that, so any event.
Powerful Kenton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall with dark hair. That was a telling
Again,
slip
he's
of the
jumping
tongue by
around.
Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows.
Now I started talking about a couple of storyline points. I wish you would just sort of weave this all into a story and bring out some of them excellent reasonable doubt data points as the story is unfolding.
That he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs.
Okay, we're over 10 minutes in, and we've not heard one point about reasonable doubt.
Wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly.
Okay, he's got great points. They're just not in sequence. Constance Lander is saying, I heard the defense should wait to do an opening until after the prosecution finishes. Is that possible legal? In every state and court I've been in, you can wait to do, you can reserve your opening until after the government's done with their case. And I think I've seen one other attorney do that. I've never done that before. I'm ready to go, and I want the jury to know right up front of how I'm going to crush the opposing case. So, but yeah, here in Massachusetts, who knows? I don't know, and maybe they don't allow it because everything else is so much strangely different there.
They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told.
I'm going to be really hammering home the point that she is home at 12:36. She was en route already to his house, halfway there, and his phone is being moved around. That's who did it. That's who did it, ladies and gentlemen. I mean, get really fired up about these kind of data points. They're just massive, massive crushing data points that show reasonable doubt. Not only reasonable doubt, but somebody else had to have done it. That's not just reasonable doubt. That proves somebody else was involved in the death, the brutal death of John O'Keefe. That's the way you got to like slam those points home.
Told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she'd left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data,
Good points, but he's reading from the script so much. It's just so much, it just makes you want to like take that podium, just throw it out of the courtroom, get rid of that. It's such a crutch, because what happens is psychologically, if you have a crutch, you're automatically going to revert to the crutch, and you're going to feel comfortable with the crutch. If you didn't have that podium there, you wouldn't have a big 3-ring binder there to flip page after page. So just many different things here that he could connect on, but looking down as much as he is, it is hurting him. It is hurting him connecting with jurors. They're not paying as much attention to him. Karen Heatley, you're saying, I think it was slightly highbrow for sure. You keep it simple and hammer reasonable doubt. All right, let's go here.
Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits.
Yeah.
And Ryan was right.
I mean, so far, he's not outraged at anything particular thing. He's like stressing things that's wrong or whatever, but he's not just like roaring in that courtroom about what an outrage this is, about how it's so blatantly obvious that Karen did not do any kind of harm to John O'Keefe that night.
Behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50.
There's Jen the Hawk. Yep. Daisy the Corgi's mom is saying, with the Commonwealth pulling so many shady tactics, it might be a good idea for the defense to open after the Commonwealth prevents their case in chief. I think it's probably better to do an opening right after the prosecution does theirs, because that may put pressure on the judge to let you be able to prove that. So if you wait till later and she's going to do everything to block it, it may be more of an incentive for her to keep more out of your points you're trying to raise on your cross-examination point. So I'd probably not do that waiting until the prosecution case is ended. I mean, she was like a hawk, except for the one time frame when you'd most need her, right?
She was very specific about that time frame, but we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows.
If you told the story of how this whole thing went down, a jury's going to go, got it. I understand. Makes total sense. These people just didn't want to get caught. Something happened. Some kind of fight flurry happened within seconds. Next thing you know, he's knocked out. He's on the ground. It's like, oh, shoot. I don't want to call an ambulance when he's here. What do we do? Let's just let him wait, put him out in the backyard or something until he wakes up and keep the doors locked, or what have you. And then, they said, well, he's not waking up yet. What should we do? Well, we don't, maybe he's going to die. Well, we don't want him dying here in the backyard or in the house. Let's get him out in the front yard where somebody will maybe see him alongside of the street. And, something like that, whatever your theory is going to be, say something like that and make it sound like this is a normal kind of thing people are going to do in a panic mode, right? And then you have Jen, who's so controlling of everything, trying to make sure everything's done right, and so scripted in her 911 call. So lay all these things out as they unfolded in real life, and jury's going to totally get that. So far, 13 minutes in, he's jumping around a lot, and we don't have a true story. He's telling bits and pieces of the story, which is all good points, but reading a script and jumping around like that, he's just not able to seal a deal as good.
Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the water.
Okay, right there. This would be right after I first humanize John and Jen and talk about how I promised you that I would prove that Jen was not guilty of this and that somebody else is responsible, some person or people responsible for the death of John O'Keefe, including a dog, to account for the injuries, and then get into what happened.
They'd been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins.
Okay, if the judge pulled a stunt like that, saying you had 2 hours in the last hour and a half or so beforehand, she says you have 1 hour. How do they fight that the next time? With this kind of judge, maybe she's going to change it to 30 minutes or something. I mean, it just shows you how jacked up this Massachusetts legal system is, where you can have a month and a half of a trial and the lawyers are supposed to sum it up in 1 hour. I mean, you can't even talk about the law within like 10, 15 minutes, going through all the jury instructions and what the burden of proof is. And then you're supposed to summarize 120 some witnesses, which is like 20 seconds each. I mean, this is like so much a rigged system to deny the defense to actually do their job. I'd be talking all the time, Judge, I'm going to be ineffective if you do this. If you essentially gag me from talking about all the stuff I have to do, you're putting duct tape over my mouth. I can't do the points I need to make in succinct fashion, in a thorough, accurate fashion, then I'm essentially conceding that I will be ineffective. So this judge probably doesn't care about anything, because all she wants to do is cut things off and deny defense a fair trial. And by keeping out this kind of reasonable argument, it's a better chance that Karen gets convicted. And that's what's the real agenda here, which is so upsetting to see.
Who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape. If you want to take another look at it, it's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, "You coming here?" This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34?
Gosh, you know this like the back of your hand, AJ. Why do you got to sit there and keep reading through the script?
Fairview that night. And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, "I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers." Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, "You know, your girl's been texting me"? A push, a punch, a fall.
Describe it how it would happen in real life. John gets dropped off. He walks in the front door or the side door. He walks in. Other people in the kitchen, they're not seeing what's going on. Next thing you know, he gets pulled told to come down to the basement. Next thing you know, he gets sucker punched. Right there, that's all it takes. It's a matter of seconds. And that's why he didn't come out. That's why he didn't respond to texts. Then you could have somebody like Jen being told, "Hey, start texting John, acting like we didn't know he showed up. We got to cover this up. We got to do something to make sure that we make it look like he was never walking in this house." So sound energetic, sound like this is how it happened, sort of like be describing it in real life, sort of be like a color commentator for a sporting event where he's sort of describing things that as they're fastly happening in real life sequence.
Pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household.
Keep in mind, you could have somebody off the street come in and read through this script and have no more heart conviction than what he's got here. So I just think he's not connecting with the jury heart to heart. And he's reading a script. And I just think if jurors see somebody reading a script, this is written by who knows who on the defense team, and it doesn't seem like you really believe it. Why would you need to read through all these things word for word? You've been sitting through this week after week after week. You've had, many months to prepare for this trial, and you're having to read it word for word like a storybook. It's just not good.
Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk?
I'm sorry, there's a question here from Beachy Stacy. Is allegedly a Commonwealth witness now reluctantly testifying? Who do you think it is? I don't know. I don't have any insight in that. Maybe someone that has the most conscience of the Commonwealth witnesses. Maybe it's Trooper Paul. Maybe he's getting cold feet because I think he could be somebody you could really push his buttons and get him to admit he doesn't believe what he's saying about his theory of how John O'Keefe was injured. So don't know anything other than my speculation like that.
What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel?
Talk about how the scrambling went, how they were up all night trying to figure out what to do, how to cover their tracks and all that kind of stuff. All this makes sense if you're trying to cover tracks. So, and be talking, it's sort of like a time sequence breakdown. Have a timeline, have charts, have a timeline breakdown of what happened. I mean, all that kind of stuff you can walk through and really have it connect with the jury. And if you do want instead of having the notes, if you basically just have a big ESOL chart, flow chart, a timeline showing what happened, and then walk us through that way. That could be a way of connecting with the jury where you're not looking down at your notes. It's all up on a big board, or you have an overhead projector or something. You can have a big computer screen on the wall of the courtroom to show all these points you're making. So it's got to be something better than him making all these points and just looking at his notes where he's losing that connection with the jury. A good example of how the actual evidence can come to life is like what we saw in the closing argument by Georgia Kappelman in the murder case of Charlie Adelson. So that was really good. There's a lot of minutia detail that they all pulled together, and they all had that rolled out. And it's sort of like what I call sort of like a movie script or Dateline special kind of thing that came to life. And that's the thing that even Charlie was complaining about after he got convicted, about how they just jazzed up all this evidence like in a Dateline special. So that's what they need to do here, is jazz it up. And if the judge doesn't allow them, then I guess at least have it all ready to go. Don't just keep renewing it and call the judge out on her bias. If she keeps saying no, just say, well, Your Honor, it's to us, it's readily apparent that you're biased against the defense. You don't like us as attorneys, and whatever it takes to really put the pressure on her that she is being blatantly unfair. You need to call her out on it. If you just ask and she denies it and you just sit down, well, then you're not being a strong enough advocate for your cause.
Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted, I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things.
Yeah, so after he does a whole timeline of laying out what happened that night and the next day and go through the investigation, how things were botched, nobody did the right job from law enforcement, and then you can get into what happened since then. And then eventually at some point you get into your own witnesses and like your experts, and then you can bring home those excellent points that
after a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible.
That's a good point here, because he's speaking from the heart. He's got a good point here. This right now, he's speaking from the heart. He's not looking down at his notes. So there he's connecting well. Loudmouth, thank you. You're saying that can the defense ask to switch O'Keefe's seats with the Reeds? It looks bad for the jury to see Paul sitting there glaring and leering over her like a angry. I won't say he's that word, but in Bez's other trials, the victims sits far behind. I don't know why they're allowing that to happen. I just think it's very strange. I agree with you. They should be asking not to switch seats, but just to prevent him from being right in the view behind Karen Reed.
Not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again.
Part of laying out the scene is also to talk about what's going on at the bar, how they were being aggressive, how they were, how there's something going on with Higgins being fixated on Karen and Karen ignoring him. So there's some kind of confrontation that was brewing there at the bar, and this is not really being brought out yet at all. As far as like a building up motive, they wanted to like bring him over to the house to sucker him into a confrontation that they didn't want to have there in public. So this could easily be explained all in the beginning part of this argument.
Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds, maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None.
There he's getting more emphatic. He's looking at him directly. I just wish he wasn't looking down. And bring this out in the time sequence of everything.
At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m.
That's so damaging right there. I mean, I'd make such a big deal about this. I would be saying, there they had John injured and John not getting urgent medical care. That's how you know that. You wouldn't ask that kind of question in a Google search unless you know he's out in the cold and there's a good chance he's going to die.
And then it was deleted. So what else was going on at or around this same time?
That's part of the cover-up. Every time there's a deletion of something, it's part of the cover-up. Again, each one of these items is a reasonable doubt. I still haven't heard reasonable doubt. We're 21 minutes into this thing.
When all this suspicious activity was happening at the Albert house and the McCabe house. 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was no body on that lawn, period, at 2:30 a.m.
Good emphasis, good voice inflection here. I'd be even louder and more passionate about it. But then he looks down again. So I just don't like the looking down. Sorry.
And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body was.
These things are just not massive reasonable doubts. They're actually proof that she's not involved in the murder of John O'Keefe.
Ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead.
Yeah, why did she ask her brother to pick her up? And then when then when he gets her, she doesn't come out for a while, and then he's calling her up. Then finally she comes out, and then she comes out to the truck to then explain why she is not going to leave with him. And that all that is strange behavior.
It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John. He walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turned to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response.
See little bits and snippets where he's laying out what happened in a time sequence is good. It just didn't do enough of it. So that'd be my advice here for anybody doing a closing on this.
By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You could see it. You don't have to wonder the emotion.
Yes, I think that's great points he's making here on the effect this was on Karen. And as somebody else pointed out here, I put your comment and removed it a second ago, but Karen's really going to act that the way she was, all freaked out because he wasn't home. He's got a daughter there in the house. He's not showing up at 5 a.m. And so it's normal for her to be freaking out. And upon seeing him, she's the one upset. She's the one that loves John. It's not Jen McCabe and her actions. So everything that Karen has done is consistent, and especially when she finds John laying in the snow there. Everything she's acted out from that point on is consistent with somebody who's genuinely concerned about him, horrified and shocked that he's there in that condition on the side of the road. She had no idea he's on the side of the road. She wouldn't have left him on the side of the road. There's no way any juror's going to believe she intentionally left him on the side of the road. Okay. Anybody that looks at this evidence and considers everyone's behaviors, Karen Reed's behavior was the most consistent with innocence. It's not the government witnesses.
Emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that.
So you're going to call somebody 53 times that you thought you killed or left for dead because he's dying? That doesn't make any sense. She wasn't this kind of shrewd murderer type of person. Her mindset wasn't that of murder at any point. So obviously the state is just way gone reckless and completely disregarded any kind of proper investigation to really find out what happened to John O'Keefe. And if you do any kind of simple investigation and even what was done after the fact and what's shown, what was failed by the prosecution, it all comes to the fact that there's other reasons that John O'Keefe was killed, and it wasn't to do with Karen Reed.
The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished when Dighton Police Officer Barrows walked into this courtroom. He's a sworn officer. He's not associated with Kenton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words,
yeah, this is great evidence. These are great points he's making. It's great that he's presenting this. I just wish they'd do it more like the Charlie Adelson murder case of the prosecution presented all the different information up there, and do your best to get it in. The judge is going to hate seeing this kind of information go up there, and but do it on the timeline, and I think you'll be able to absolutely nail it.
he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look.
Yeah, what's the motive here? The prosecution is saying that a fight ensued on the way to the 34 Fairview. With a fight ensued, then why would they even go to 34 Fairview? And she's waiting to see if it's okay for her to come in. If they're fighting, why would they even be doing that? And then all of a sudden she's going to go on some rampage, some murderous rampage, just a drop of a hat to try to run him over with a car. It's impossible to run over somebody in a car going in reverse. And the timeline's all jacked up. Jen McCabe is proven to be completely off on her timeline. And she didn't realize when they came up with their stories how there was other digital data that would prove that their timeline was completely botched and proven to be a flat out a series of lies.
Look at this photograph and tell me, Which one looks like Officer Barros's description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so.
That could be a great point that they should raise and then point the finger at him as he's sitting there in the courtroom. That's somebody you should be pointing the finger at.
Recall that after John's body was discovered, Blank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades.
Put this in the time sequence. Great points, but put it in the time sequence.
At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention. And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to
All right, we're 31 minutes in. Nothing about reasonable doubt yet.
interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls?
Is Jen McCabe likely to revise her timeline for this trial? If so, can the defense show videos or audios of her testimony in the first trial? Yes, they can. They could also show a transcript. Usually attorneys like to use transcripts rather than a video or audio, but I like audio and video the best for showing somebody is a liar.
Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them.
Yeah.
And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second.
This is a lot of looking down, folks. You should never have your eyes off the jury, except maybe if you want to look down once or twice before you're ready to wrap it up, make sure you didn't forget something. But this should be like the back of your hand. You don't need to refer to this big 3-ring binder nonstop.
Because this was a concerted effort by Michael Proctor to falsify the time the car was seized.
Okay, you're saying emphasize the physics, science data, and the Holes investigation, what the investigators miss, and how that means Karen could have hit John. I agree with those points.
So that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene.
He's jumping around on the investigation. He's not talking about sequentially how they botched up and what they should have done when it was happening.
But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon.
Every point he's making should have a point of reasonable doubt. Especially if you just got an hour and you got to cram all this in within an hour, definitely got to hammer home reasonable doubt. He should be saying reasonable doubt like within every 30 seconds.
He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the addition.
Yeah, I mean, just everything you have to point that there was evidence that was completely tampered with, manipulated, moved, set up, broken, all this kind of stuff. You need to hammer that home and really get aggressive in your argument with it. I mean, how often do you have that in a criminal case where you can actually show that your client, the forensic evidence completely shows your client is innocent? You don't see that in a lot of trials. There's always like, well, what's making the most sense? But here we got Karen not even around the time that John's phone's still being moved. You got the fact that the tail light looks like it's mostly fully intact. 90% of it's there. There's a little bit piece missing where there's a little bit of white showing through. And then later on the Sally Port, they're saying the whole thing was completely smashed off, like 3/4 of it. So this is like really massively great stuff that they should just be really making a huge deal about it. And he's not really making a huge passionate deal about this kind of stuff like I would want to see from a defense lawyer.
Additional physical evidence or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. That magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what the actual...
I disagree with this. Hope is saying no, Proctor cannot plead the fifth, confirmed by a lawyer. Well, actually, he could plead the fifth because there's a federal crime, civil rights deprivation that he would be could be charged with. So technically, he could plead the fifth if you look at federal law.
Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000.
Yeah, bring this out. Gitmo Holiday saying Proctor did hide Lucky, but also hid the tow truck driver. These are major flaws in the so-called investigation that he could just be roaring about that here in his closing.
Pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think?
This is stuff he should be really driving home with much more passion than what he's describing here. He's reading out of a script, and when you read out a script, you're not going to have as much convincing passion.
Someone not want you to see what the condition of the taillight was at that exact time. But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight, while he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was
make a huge deal about this with your voice inflection, your tone. He's doing, I would say, too much of the same tone throughout this whole thing. He's emphasizing certain things, but I would really emphasize things like when you got fraud and data manipulation, you're messing with the crime scene evidence. This is stuff major. He could really make a huge deal about these points with his tone of voice and how loud he is. Being courtroom appropriate, but really massively driving these points home more than he is here.
not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case: lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree.
Yeah,
Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lank, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower.
The only reason they had no other taillight fragments found is because there weren't any, because they were planted there after the fact. If that's not an attempt to frame Karen Reed, then what is? And just really hammer those things home with those kind of persuasive, passionate type of statements to the jury.
One piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on
Not enough outrage here, AJ. You got to have way more outrage.
January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard.
Not aware of any, Maya.
Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there.
You see a consistent thing I was saying as he's looking down too much, reading his notes. He's standing behind a lectern, never once mentioning reasonable doubt, didn't tell the storyline. So he started jumping all around. If you jump around a lot on stuff that's got a lot of moving parts, you can lose a jury. And so you got to have more steady eye contact to make that kind of heart-to-heart connection. You got to read the jury to see how much they're really buying into what you're saying and adjust your argument accordingly.
Accounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about. Those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not Stop and Shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew?
You know, throughout this whole thing, he could have started in the beginning and talked. He'd just play the 911 tape in the beginning. That's one way you could have started this out after introducing what happened that night. go to the 911 tape and then talk about the storyline if you want, or bring up the 911 tape as it happens as you're relating the story. And in every one of these points, say that reasonable doubt, that one doubt is enough to acquit. Just one reasonable doubt. You don't need all of these. So you're giving reasonable after reasonable doubt points at least one every 30 seconds throughout an 1 hour closing on average. I mean, think about how persuasive that is. And yet we're here 44 minutes in, and I've not heard reasonable doubt one time.
No, there's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opened.
I'm just telling you, the 911 call by Jen McCabe just makes this whole thing about how this was a cover up because a fight broke out and John went down. He was ganged up on by some men and a dog and put out there on the street. That's what most likely they would argue. And you got some kind of data and facts to back it up and mention all the details that show reasonable doubt. And just one of those is enough where they must acquit. And so going 44 minutes in and you haven't driven that point home, they're not really thinking reasonable doubt. They're just trying to think of how do I connect all these dots that he's jumping around. Yeah, he's making sense here. And you also have to worry about losing the jury if you don't tell at least a storyline up front. But that 911 call where Jen sounds like she's whispering, like she's in a library or a church or something, that is just so extremely bizarre. And it's almost like, and then I'd be arguing things like, the reason why, if you recall, she said in court that Karen wanted to go right away to 34 Fairview. She initially didn't remember it when they're on the phone that she went there with John, but then afterwards she's like, "We got to get 34 Fairview." And what did they wind up doing? Not bringing Karen to 34 Fairview. More time was involved. It almost like I'll be arguing that was a delay tactic. Jen McCabe mastered a delay tactic so that there was more time for things to get taken care of back at the house. So all that kind of stuff is what how all the timeline plays in. So you got to nail this timeline down because you don't really cover this timeline well. If he's talking about 1236, 1232 with John making movement, if you don't show a timeline on it like Lally did, a jury's just not going to connect as well. A jury that's not as savvy and smart like you'd hope them to be.
Opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the two red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red.
I would include the storyline of how they actually processed the so-called crime scene there by the flagpole, and then talk about individual witnesses thereafter for the government and what you were able to extract from your cross-examination.
Red pieces of plastic. And I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to.
If you also had like an easel with all these things or a computer screen flashed up there real big for the jury to see, then you could like move through these quicker because they can read them. You can highlight them one at a time. And then, so if you are having a judge that's going to condense you down on short notice, oh, hey, instead of 2 hours, I'm giving you 1 hour, you would be able to more easily adjust fire that way. But Anyway, just going through your notes here, not as easy to do.
5 to 47, ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question: who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37, and see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers in Canton Cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence. And now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth.
Yeah, he hasn't talked about the solo cups yet. Let's see if he gets that here. He doesn't talk about reasonable doubt yet. I mean, he's got, this goes to the 1 hour mark. So he's down to 13 minutes left.
Presented about 67, maybe more witnesses, and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview. John got out of the car. She reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe, or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house.
I think the reason that the judge has flipped her script on how none of these kind of demonstrative exhibits and evidence can be presented to a jury during argument is now changing, because she wants as much that the prosecution can bring in on Jen's statements to media. So she wants to have a lot of stuff from Karen coming in on the media. That's why the defense needs to counter it with the 911 tape. They need to play the 911 tape. Even if they got an hour, that 911 call is so critical. I can't emphasize that enough. That really sets a whole scene of credibility and believability for Karen being set up.
That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but 2 thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an...
okay, he's 49 minutes and 35 seconds in, and we haven't seen any pictures of John's arm yet either.
Animal, likely a large dog, which means that John was attacked inside the home.
It's just
where
common
Chloe
sense. You don't
was.
need a doctor to see that's
There
not
is
a
no other
vehicle injury.
possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're
Okay, I think that's the first time. 50 minutes is the first time he brings that up. He needs to be hitting that home many times in his 1 hour, many times.
consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available.
She's not hitting it now because she wants to get Karen's words in there. You don't see normally a case where you have so many different times where the defendant's words can be put on actual audio tape. Keep in mind, none of the other witnesses that are interviewed, none of them are on audio tape or videotape. So because we have Karen and many hours of her talking, that's why she's like, now suddenly she's on board.
By the way, to the Commonwealth, they could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is.
I don't know. It's for me, when I just see this automatically, somebody read from a script, I automatically am like tend to think of other things. I'm sort of bored. Now, obviously, as jury, I would not be doing that because I understand my role as a juror. But, people have short attention spans, even more so now with smartphones and media and all that kind of stuff. So you really need to grab their attention. You really need to have that eye contact. If you don't have eye contact, their minds tend to wander. And you need to, if you don't have the timeline spelled out in a big kind of projection on the wall there in the courtroom, and you don't walk them through the story, you got to be a good storyteller as an attorney. He's not doing a storytelling at all. He's jumping around showing you little pieces of it, but you need a sequential storytelling function as the trial attorney for this case.
Yet another fact
8
that
minutes
establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, period. And that is yet another fact that establishes reasonable doubt.
Okay, now this is only the second time he's talking reasonable doubt, 51 minutes in. So now there's only 2 points of reasonable doubt.
You'll remember as to this case, O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the.
If you need to read this much, you need to have it on a projector, some kind of big image for the jury to see, and you walk them through it that way. This is not good. It needs to be a lot better than this.
Shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement. before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rinschler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rinschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, "You can't deny the science and the physics." John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's.
Okay, there he's saying he wasn't hit by the car, period. How many times have we heard that here? Now 53 minutes in. So much being using that as a crutch, the notes and the
injuries.
podium,
They can't
the
explain
lectern.
his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone.
We did have it on his arm.
Nothing
Talk about
to
the arm.
suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, a whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple.
Talk about how ludicrous it is and how he would have been hit and spun around and gone 30 feet in the air, and yet none of these other injuries. You really got to mock this ridiculous theory of the prosecution. I mean, it's really laughable in a way. This is a murder case, and you're saying this is what happened to the body? It defies any common sense. You don't even need an expert to understand it. What Trooper Paul is saying happened to the body of John O'Keefe is not possible. It's humanly not possible for that to happen, and really be outraged at this.
John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that.
He's not really driving that point home with really a huge amount of passion and holding up the picture, showing the picture of his arm, saying, "This is a dog bite. This is plain and simple a dog bite all up and down his arm. There's no other explanation. A car cannot do that kind of damage. There's not any kind of damage on the car. His right arm could not have hit that and caused this kind of injury. It is so abundantly clear and obvious." And Karen was already gone anyway. Karen had already left. She was halfway to John's house. His phone's still moving around. You can hit all these different points and hit him hard with much more passion. And there's just not enough in different voice inflections on this to really drive these points home how absolutely insane and ludicrous the government's theory is on this case.
Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue?
There's too much over the top type of language. You need to basically say and implore the jury to look at this case and say that all these reasonable doubts will drive home the fact that John O'Keefe was not killed by Kieran Reed. We have actually proven that he was not killed by Kieran Reed. He's not killed by a vehicle. He was beat up and attacked by a dog. He was beat up and attacked by a dog. That's what the evidence shows. That's what we have for all the data to indicate he was moving around after Kieran had already left. He was out of the car. We've proven that he's out of the car, and go into all those kind of details and actually show that and implore the jury to say that the one way you can actually find the true killers is to actually show the prosecution that you have not proven your case. Kieran Reed is not guilty of these charges, because if you do that kind of message and sign off that she's not guilty, that is going to force the government to actually do their homework, to actually find the real killer. But if you actually would find somebody that's not guilty as guilty, then what that does is it gives them these folks that actually did this killing of John O'Keefe, it lets them off the hook. They'll forever be let off the hook. It'll forever be an injustice. And then you need to drive home this reasonable doubt thing, like I say, frequently, over and often again. And then talk about the reasonable doubt that they need as jurors to be able to go home and sleep at night. I bring that up whether I'm a prosecutor or defense. I say that you need to have any reasonable doubts. You better have them here and now while you're in the deliberation room. Don't be like other jurors we've heard about that wake up after they've voted to convict, and then they find out, oh my gosh, I didn't consider this and that. Oh my gosh, I should have listened to that. Oh, I was sort of in a rush to get home to go let my dog out. I should have voted not guilty and stuck to my grounds to come back however many days it took. So make sure you have all your reasonable doubts now, because you can't come back later. You can't come back to the prosecutor and say, hey, I want to change my vote. I can't sleep over this. It's just got me so upset that I didn't listen to the defense, and now I know for a fact I voted to convict and that was wrong. I went to the judge, and what's the judge going to say? The judge is going to say the same thing. Your vote is final. We can't change it. Don't be the person that has to hire a defense attorney to clear your conscience. You need to have your conscience cleared now and look at all this evidence and realize that the government has not proven their case. This has massive amounts of reasonable doubt. From A to Z, it's full of reasonable doubt. There's no way anybody has testified with any kind of accuracy and credibility that Kieran Reed was responsible for John O'Keefe's death. In fact, the government's witnesses, all these multiple witnesses that came in here and said stories that were not corroborated by digital forensic type of evidence. And if they lied on one thing, you can't believe them on anything else. If they're willing to lie in court on butt dials, on where they're at, where John was at, or where Kieran was at, you can't believe them on anything. So the government has not shown you any credible evidence as to how these injuries have happened. If you are asking yourself, what really happened? How did John die? That's massive reasonable doubt right there. It's game over. It's end of discussion. The government has not proven their case. You must acquit, because the case evidence does not lead you to anything other than the fact that Kieran Reed is not guilty, that Kieran Reed is innocent. So you do something like that and drive home that point of reasonable doubt. And then you also got to go through the instructions. And what I've done before is like either show up on a screen or you show the actual document that they sign and walk them through the actual verdict form. And you say, you can check right here, not guilty. You can check right here, not guilty to count 2. You check right here, not guilty to count 3. So that's the kind of way you walk them through that. And so then even and ask them, I think what we had in the first case, to say, you guys can't pick your foreman. The judge is going to pick them for you. If you have a question and the foreman isn't asking it, I would try to blurt something like that out. Go ahead and ask the question of the court, even if the foreman doesn't ask you. That's something that's really critical here. We had this foreman that was able to squelch any kind of question and and confusion is what were we supposed to do with this really confusing verdict form? Because I think it's going to be very confusing this next go round as well. I think that's part of the game plan to keep it confusing for the jury. So it makes most sense to just to follow the form and follow the vote to convict, because it's just otherwise too much convoluted and nonsensical.
Well, this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object, and he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl.
He's not talking from the heart.
And cover for the homeowner because he's a Boston cop. That's how you rip a
It doesn't
person's
come
life
across that
apart
way.
and sleep like a baby while doing it. And then
When you're following a script, you're not coming from the heart. It's not spontaneous. You need spontaneous statements from the heart.
further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth. And I did that because that's what this case is about. Top to bottom, tip to tail. It's about the truth, not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling. It's not a whim. It's unflinching. It's unchanging, and it's everlasting. That's why
I heard they all got colds. That's why they looked defeated in court the other day. So hopefully with this long Easter weekend, they get a chance to recover and they'll be ready to be rip roaring on Tuesday.
the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth
Gosh,
has
where's
met
all
its
the freezing
incredibly
out?
high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the
Okay.
highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this.
Okay, that's good point. I like to also explain what that means, sort of more layman's terms, like, okay, what does that mean in moral certainty? And then talk about what decisions you make on a personal basis that are so critical in your life, the most important decision in your life. That's how convincing you have to be that the government's proven their case.
You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt and to a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
Okay, he didn't talk about the verdict form. I think he had good points he made here at the end, talking a little bit about reasonable doubt. I just really believe if he would have weaved the reasonable doubt in from the get-go, played that 911 tape, that really sets the scene. He doesn't tell the storyline on how this frame job, this setup, the conspiracy happened, and the frame job is so critical, and it's really a complex thing for a lot of people to think, what, somebody is framed? I mean, and a lot of people saying, what, 8 people in a house are going to lie about it? Well, tell the story how it laid out, and people say, hey, yeah, that makes sense. That really makes sense. Just talk about it as it rolled out, and go through it, and talk about how a fight can happen radically quick within seconds. A fight could have broke out. It was actually brewing um, back at the Waterfall Grill and Bar. So none of this has to be really far-fetched kind of stuff where they make it sound sort of like what really cerebral. Oh, this thing is really hard to follow. Nobody says he was in the house, was in a discussion. I mean, that's really a simpleton approach to think that people cannot formulate a intent to cover something up in a matter of seconds after an event happens within a matter of seconds that makes certain players and actors guilty of a crime. So especially if they're law enforcement, they know how to act to get other law enforcement off their tails. So anyway, we're almost
Thank you very much, Mr. Jackson.
so much of the time, I'd say I'm just guessing off the top of my head. How much of the time would you guys say that he didn't actually make eye contact with the jury? I mean, it was probably close to half the time, maybe at least a third of the time. I guess sometimes it was a third, sometimes a half. I don't know. You're just missing a lot of connection points. So that would be my recommendation. So, I mean, was this closing enough to seal the deal and show that the jury should acquit Kearney? Absolutely. So I just think that the second go around, I really think who's going to be able to connect most with the jury without having to look at notes. I guess which of those attorneys is the best able to argue without looking at notes? And whoever's the best at arguing without notes, doing a closing without notes, maybe the best one to use. But if somebody needs to rely on an outline like this and almost read it word for word, that's not something I'd want to do my closing on a team I was a part of. So I would say they need to have. My guess is Alessi. I've been saying Alessi should do it, and he's maybe not so burnt out by this. I mean, there's also a chance that you're sort of burned out by some of this. This is your second go around. You spend so much time. Something like Jackson is away from his family and his lifestyle back and all the way across the country in California. So maybe I let him be lighter on how much of the questioning there is of witnesses, and having more of the local guys, Yannetti and Alessi do it, and then Alessi doing the closing, I think would be the best thing because he speaks really from the heart. He speaks with conviction. He's super intelligent. He's not overly slick and flashy. And I think that connects with the jury. I think the jury will connect well with him. I think Yannetti is also very much a guy that speaks with conviction, and he's likable. All these attorneys are likable. I just think that, based on my experience on how juries interpret closing arguments, I think Leslie would be doing the best service for Karen Reed. So with that, I'm going to go ahead and jump to questions now. We're a little bit over 2 hours. So if you have questions, put a red emoji if you're able to do that. Yeah, Margie, you're saying that AJ missed mentioning even the DUI and leaving the scene, which is one of the only charges the jury hung up on that. Yeah, he didn't. I mean, maybe that's because he got condensed down. Maybe that was something you had to peel back. But if you go through the verdict form, then you automatically you're going to cover that. So you need to have at least 10 minutes in your argument when you start getting to jury's instructions at the end. Razor's Edge, you're saying AJ Prudy being good on his feet with the witnesses, but trying to get perfection with the closing isn't working. He knows this. I'm telling you, he knows this case good enough. I'm not saying he doesn't know. You know how many times I've seen lawyers just go into court and wing it. They don't really know the case, and they don't study it beforehand. They sort of find out about it during the trial, and then they wind up just trying to do a winging closing, and the facts aren't really gelling in their mind. They can't really speak from the heart. And in this particular case, I mean, he knows the facts. He's super intelligent. He can do this. So he would be he would be just fine if he just took these pointers into practice, I would say. But like I'm saying, Alessi being more of a local guy, I think being a guy from California, he's just not going to connect well. It's not a strike against him at all. He's just not AJ's just not going to connect as well with jurors there. So I think Alessi is my vote for who's best to do the closing. All right, and you're saying it wasn't enough for a hung jury, wasn't enough for an acquittal. Sadly, too jargony, showman-esque. If Jackson was more concerned with the pancha and cameras, yeah, I don't think he was trying to be too much of a showman. I mean, I think that's what a lot of attorneys do that I've come across. Is that they want to read a script. It's most comfortable. They don't have to. I mean, imagine the mental pressure you're under if you had to pull all this together. But for me, if you've been sitting through the trial, you should be able to do that. So I wouldn't want a crutch, but I think a lot of attorneys like crutches. They like to have it scripted out. They like to have their cross examination scripted out, their direct scripted out. And to me, that's what separates the best from the not so great. Ellie, understand reasonable doubt, explain it and drive it home. I mean, that long, convoluted instruction on reasonable doubt, I'd explain what it means in lay terms. He talked about moral certainty, but I'd equate it more to something like I've done before, which is more like a football field. Sorry. How the prosecution starts out in the back of the end zone in the bleachers, and they got to drive and march the ball all the way down the field past the end zone of the other side of the field to like 130 yards in order to be able to get a conviction. That's what it's like having a presumption of innocence and how much the burden of proof is on the government if you equate it to a sport like football. And then say basically that they have not even driven the ball forward at all. They've actually backed up and proven the fact that Karen Reed didn't commit the crime. So that's what I would argue, something like that. Maybe females on the jury may not relate to it, but guys on the jury would. And so if you have to do some other type of analogy for females, and you can do that as well. We have like a 50-50 split here right now, where that includes the alternates. So yeah, I think Leslie's saying should the closing be more focused on reasonable doubt than being innocent, as AJ said in his closing. I mean, I argue that I can prove my, and I don't use my client. I say the name of my client. So I hate that when I hear lawyers in court saying my client this, my client that. Humanize your client, say their name. But I say that I mentioned that they're innocent a few times because this is not a matter of finding them innocent, because there are obviously some indicators of guilt, certain things that come out in any trial. They can be indicators of guilt, right? So what you're trying to look for is, though in Karen's case, you actually do have more indicators of actual innocence, like the fact that she has an alibi. I have a video out there on a live stream we did when I was at a week or two ago about the fact that she has an actual alibi. So not using an alibi instruction here, which I think would be helpful. But in any event, I would argue that she has an alibi, even if you don't get that jury instruction. But hammer home reasonable doubt over and over again. All right, and you're saying you really like Karen's team, but a little too much showmanship in the closing. Stick with the ridiculousness of the evidence and just be reasonable doubt on every one. Let's see here. You guys are talking about Leslie. So let me see here. Kim, you're saying, can I explain the Commonwealth expert on accident after troopers Paul testimony? How can it change from first testimony? I don't know what this. If I read your question right, I don't know how they're going to bring this expert in, and is he going to say something different than Trooper Paul? I can't believe anybody would embarrass themselves with the kind of testimony that Trooper Paul says. So maybe they're going to come up with a different theory than this hitting the arm and spinning around. I mean, none of it makes any sense. It defies common sense, and that's why they should lose and will lose. Kate, you're saying I think Agios is being himself. A lot of good points, but Alessi would be better for this closing. Christopher Carriera, you're saying, isn't closing arguments not supposed to be the evidence anyway under the law? The jurors saw the trial. The Commonwealth did not prove the case. It was laughable. Yeah, he has. I know they have this one expert has a 140-page PowerPoint presentation. That's the expert to combat the ARCA experts. There's no way that's going to be able to beat the ARCA experts. Ms. Smith, can you mention how low the bar is to arrest someone and take them to trial to really hammer home reasonable doubt is so much higher of a bar? Some jurors think that because she's guilty, she's on trial. I mean, you could do like there was in the O.J. Simpson case where the defense argued that you can think that somebody did it, which what I've said many times before. You can think somebody did it. That's not proof beyond a reasonable doubt. There has to be solid evidence to back it up. You can say it's highly probable that somebody did it. That's still not high enough proof. You have to have the evidence to back it up. And you can even say it's most likely in all possibilities and probabilities that someone did it. That's still not enough. You have to have proof beyond a reasonable doubt. And so you're not talking about possibilities or probabilities or even that you think. You can be 100% certain somebody did it. But there has to be proof, convincing proof. And if you don't have convincing proof, you must acquit. And so that's something that that the defense should have driven home as well. Hopefully they'll do that this time. Especially that's important because you have this convoluted jury instruction on reasonable doubt. It's just nothing but a page and a half of confusion bombs, as I call them. Kathy Smith, you're saying she's guilty. Okay, Kathy. Well, I don't know how much of the evidence you've seen, but I can just tell you from all the many thousands of cases I've had, you take any prosecutor that looks at this case with an open mind, they're going to tell you, don't go to trial on this with Karen Reed being the defendant because you don't have the evidence there. Is there any attorneys on YouTube that say that there's enough evidence against Karen Reed, or is it just a bunch of naysayers, non-lawyer, non-experienced people talking about it? And like I've said on some of my videos, if she doesn't get convicted because the prosecutor's hiding the ball so much and the judge is rubber stamping that effort, then this is going to get busted on appeal. So there's no way in the end she's going to wind up as a convicted murderer or a convict of any of these charges. Salem, you're saying Karen didn't destroy any phones, hide her car. They found zero incriminating things on her call, etc. Yeah, who's got all the stuff to hide? It's all the folks that are in the house and the law enforcement types. Susan, you should talk about the pattern of blood down in front of John's clothes. You could talk about that, how the fight ensued, how he got punched in the face, blood dripping down his nose, he got whacked in the back of the head. Whatever your theory is going to be on how he got hurt, that's what you should be arguing. And we didn't really hear from AJ about how did the fight actually break out, where we been hit, how could he been hit, or suggest what it could be done. And I mean, the prosecution suggesting they got in some big, huge blowout fight on the way over to 34 Fairview. Well, with those kind of injuries, we know it wasn't by a vehicle. So obviously he got beat up by somebody and also attacked by a dog. So explain all that and how those kind of things support you, how the bite marks in the clothing, those depression marks in the clothing show that helps support the fact that it was a dog bite. And the blood going down. So if he's dripping that blood, it would imply he's stood up for a while rather than being hit his head on some ground. Then how's it going to be dripping down the front of his shirt? Eddie Mack, you're saying she's only guilty of being gaslit by Jen. Beachy, yes, I think Garrett Wing will be important for this retrial. It depends also how much the judge lets in. She's just cringing over the fact that he's got some good stuff to bolster the defense with. So she's going to be looking at ways to shut him down as much as she can. But she's allowing some of his testimony to come forward, so that's good to see. Louis Abel, you're saying, is it better that the jurors already know about this case? Well, I think it's hard to find jurors that don't know something about this case. If a juror doesn't know anything about this case, then how can they even be fit to sit on a jury if they're that sort of clueless of what's going on in that community? Christian from Manhattan, how do you see Brennan arguing a different theory from trial one, Trooper Paul versus Judd Welcher? I don't know. All I know is he's going to try to do as much spinning as he can, and Trooper Paul versus this Welcher guy, it remains to be seen. But I would say, is Welcher going to say the same thing as Trooper Paul? That's laughable if he does. If he comes up with something different, then they got conflicting theories. That right there is reasonable doubt. So this thing's got either absolute proof that Karen could not have been involved to reasonable doubt. Every which way you look at evidence, there's reasonable doubt. Feral Cat Lady, what do you think about my thoughts about Judge being forced to be biased? She has to know she's walking the line. Why would she risk her career? I just think it's all politics. It's all politics, and she owes different people to help get her where she's at, and she's got loyalties there. Not to justice, but to the folks that she's got connections to. Catering, you're saying focus on the cop that witnessed Karen's car being towed from a house. He did not see a taillight smash to smithereens. Yeah, I mean, they didn't get a chance to argue that and understand, but there's so many other things that they could use this time for of detailed facts of the case to help show innocence or reasonable doubt. Celery 08, you're saying the 911 call is really odd. Jen doesn't sound like she's calling about a Boston cop down. No, not at all. Laura, I know they can't say it like this, but if they could find a creative way to say, if you wouldn't bet your life that she did it, then don't bet hers. I like that phrase. But that's probably higher than proof beyond a reasonable doubt. But so there'd probably be an objection to that. But it's basically to such a certainty of conviction that you can sleep good at night. So that's a really high standard, and there's no way any prosecutor can meet that. There's no way a prosecutor would want to try this case unless there's some other incentives to make you prop this ugly thing up. Karen is the only one who didn't have odd behavior that night. Yeah. She didn't act professional the whole time. She didn't use the right. She didn't have the right word usage the whole time. She sounded angry. She sounded like she had too much to drink, but that did not translate into being someone that had a vehicle and tried to run John O'Keefe over. No chance at all whatsoever. Uh, Melanie's, you're asking, have I discussed Dr. Stonebridge's testimony? The defense declined to cross-examine her as one of the most egregious mistakes. Yeah, I don't get that at all, and I've not talked about it, but I think that you don't ever leave an expert without having them cross-examine and drive, even if it's just to drive a point home, but just leaving it where it can be consistent with a motor vehicle strike. I just don't agree with that at all. So yeah, that's something that hopefully they'll do it differently this time around. Lynn Downing, can you also not only say it's reasonable doubt, but also evidence of complete innocence? Yeah, I mean, but you don't want to have to make that your burden is to prove that she's innocent. The burden's not on you, but I always argue that I've proven that that the defendant, who I won't say the defendant or my client, I say the name of my client, prove that they're innocent of the charges and accusations, and then um, so I don't think you need to even emphasize that even higher by saying complete innocence, because I don't want to actually make the jury think that I do have the burden or that I do have to prove innocence beyond all doubt. S. Ray saying, I agree with you, but it's weird he stumbled out to die right where she was parked. Well, if he got beaten in the head so bad, how did he didn't stumble out there, right? I don't think the defense is saying he stumbled out. I think they're saying that he got taken out inside the house and was lifted there by a couple of guys out to alongside the road there. All right, let's see. Moving along here. No, they had probable cause to go in the house. That's done all the time. And you don't need probable cause. They could have asked for consent. What's he going to say? No. Brian Albert is going to say, no, you can't have access to my house. That if you would have done that, that definitely would have helped get probable cause from a warrant from a judge. Plus, what about exigent circumstances? They could say, hey, somebody's dead out in your front lawn. He's a cop. We need to rush inside. We need to make sure you're all safe. Can we make, we need to search your entire premises to find out if there's any other hostages or deceased personnel. I mean, that's all it would have taken. I'll be the judge says, I truly wish we could have a constructive debate on those who think Karen Reed is guilty. I'm genuinely curious about how anyone believes there's enough evidence here for a conviction. Yeah, you know what? You know what I found? The people that think that Karen Reed is guilty, all they do is make labels and they resort to name calling. That's all they do. They try to slander people, they try to name call them, and they'll put a spin on some facts or whatever, but they're really angry, hateful people. So anybody that disagrees here, I don't have any anger towards them. I don't have any. They can think what they want. I'm not going to call them names. I don't think it's anything to get upset about. I just look at the fact that they haven't seen enough of the facts and they don't understand burden of proof. They don't understand the law. There's so many things they just don't understand. So I'm not going to get emotionally invested in that. But there's a lot of vitriol, hate on those that think the government's not proven their case and that Karen Reed should not be prosecuted. But it's very a slim margin. I think the folks, from what I'm hearing, that most all the people, especially around that Canton area, they think this whole thing is a framing against Karen. So it's a big cop cover up. State Pause, you're saying, what if the corrupt cops get to the jury? Are you worried for Karen Reed? Well, I think that any kind of jury tampering that could be going on and the rigging of how the judge fixed the foreman, and I think is the most pro prosecution based on her intuition, I think is wrong. And so you're just not going to get 12 people on the jury that are all in on it. So I just hope they have more of a backbone that we had in the last trial. And I think using this argument about reasonable doubt and you must sleep good at night, don't have a guilty conscience after you go home and then try to figure out, and every turn you go, the only option you wind up with is paying for a defense lawyer for the defendant you wrongfully convicted. Samaria Graham, you're saying visual will be a very effective tool. I think that's one of the reasons the judge doesn't want those to come in the first trial, and maybe because you got Brennan doing it and asking for it this time. Now she's saying, good, there must be some good stuff to use against Karen. So now I'll allow them. So I hope the defense has their own exhibits, blown up exhibits, and presentations on the big screen to present. They never talked once about Brian Albert. When did he talk about Brian Albert acting like he's guilty, staying in the house, police officer? He didn't talk about the dog being rehomed, the dog not being there when Jen showed up. I mean, there's so many things that were missed in this closing on details. If a lot of those argument points were just brought out in a sequential fashion, you would have covered a whole lot more and got a lot more in, I think. Celery '08, big one is at the reasonable doubt list. Wouldn't police have gone into any other house when an injured man was found on the lawn? Yeah, absolutely, they would have. All right, let's see. Who's going to go? I'm going to do a couple more questions and call it a day here. Another monitoring saying, I believe he got in a fight in the house, mutual or otherwise, fell, hit his head on the hard floor, and a major cover up in there. Yeah, I think whatever it was fast moving. I don't think these guys were going to try to hurt John if they were involved to the extent that he was going to die. But things got unfolded, and they're probably worried about what they would take the blame for. So S. Ray, how about emphasizing she has no prior, zero history of violence? Well, you can actually call witnesses, say she's not a violent person, she's a peaceful person. So that's something that if I have a client that has no criminal history, absolutely, I bring that out every single time. Absolutely. I don't know why they're not going at this route. Dusty Blue, you're saying visuals are effective because they assist some jurors who are visual thinkers too. Absolutely. I'm one of those. I definitely need the visual to help learn. Big plus on learning. Another monitoring, you're saying, I look forward to the prosecution proving one, the dog is still alive, and two, it is the same dog. Okay, with that, guys, I'm going to go ahead and wrap it up. Thank you for your focus and attention on the justice for this matter for Karen Reed, who's been wrongfully prosecuted. The evidence is not there to convict her. This is more and more the way you look at this case, the more details you get into, you really see that this thing is a setup, it's rigged, and she's being denied a fair trial. The reason she's being denied a fair trial is because the prosecution doesn't have the goods to deliver a conviction. It's plain and simple. They don't have a case. It's hide the ball, trick the jury, and that's the only chance they have to get a conviction. So with that, we start the trial on Tuesday with opening statements before they call our first witnesses. So it's going to be really painful to watch. It's going to be very ugly to see all the spin being done. But I believe in the end, we are still going to come up with a not guilty across the board for Karen Reed. So stay tuned. I'll try to follow the trial every night that it as a recap. So I don't have an exact time yet. It may fluctuate from day to day, but I'm going to try to be available to do a live stream at least every night after there's a trial. And so we'll go from there. Hope to see you involved in this case. Thanks for supporting the Justice Mission. Y'all have a great Easter weekend. Take care.